Hello again, everyone, and welcome to Quigley on Divorce, a behind-the-scenes look. I'm your host, James Quigley, joined today by two of my team members, Shana Vitek and Jordan Rosenberg. Guys, thanks for joining.
Of course.
So we're hoping to continue to get the word out about some of the things that affect us on a day-to-day basis. Where, as you can tell, doing our podcast a little differently today, all remote, and trying to do this as safe as possible. We have an interesting topic today, at least interesting to us, and hopefully will be to you as well. And it's one that we're dealing with on a fairly regular basis, and it deals with the issue of the termination or the possible termination of an individual's right to receive maintenance as a result of what they refer to as cohabitation. So the law in the state of Illinois basically says that if an individual who's receiving maintenance, formerly known as alimony, receives or lives with someone else on a continuing conjugal basis, they lose that right to maintenance. So as a starting point, Shana, Jordan, the question of what does that definition even mean? It doesn't sound very clear. It doesn't seem very concise when you talk about living with someone on a continuing conjugal basis. You know, how is that interpreted by the courts?
And it isn't very clear. There's no specific checklist or anything like that that the court looks at. What they're looking for is a de facto marriage. So a marriage in fact, or two people who are living together mainly with the purpose of avoiding maintenance is why they don't get married. So they could be living in the same house. They don't have to be. Basically what they're looking for, the phrase now is intended permanence. Do you intend to spend your life with this person? Do you share things such as finances with this person? I actually thought as we were starting this video, it'd be interesting to see if whether people shelter in place during COVID with the significant other, if that would be a factor that the court would consider moving forward. So I thought that was kind of interesting. But the court will look at anything from whether you send a holiday card together, whether you vacation together, but one fact is not all it takes. You need collectively a situation where basically they are acting like they're married. They're intending to spend the rest of their life together. They're just not legally getting married.
And I think that's a good point, Shana. And a lot of these cases, what we always talk about, they're so fact-driven and they're so unique. And each case presents its own set of facts as each relationship has its own differences and uniquenesses. And so just again, kind of chiming in on your comment where it's really a holistic view of the entire situation where, you know, not just one vacation together, not just one holiday together, not just one birthday card that they send is in and of itself indicative of that relationship. It's more the entire picture. And if you think about really the policy behind terminating maintenance, the purpose of maintenance is for an ex-spouse to continue to live the lifestyle that they may have enjoyed had the marriage not terminated. And if now the person receiving maintenance is being supported by someone else who's not the ex-spouse, then it makes sense in terms of a policy to say, okay, the person who's paying has no longer an obligation because that individual is being supported by someone else outside of the means of whatever the marriage would entail.
Which I think is interesting because even if somebody gets remarried, what if they're not being supported by that person? So I think that's interesting because clients often say to us, well, that's not fair. My ex can get remarried and I can't, you know, what if I want to marry somebody who can't financially support me? So I think that's always an interesting question that comes up.
Yeah. And while that is interesting in sort of a, you know, I guess policy standpoint, for the discussion legally, for those of you that are listening along or watching along, whether it's fair or not, that is the one bright line test. If you get remarried, you're done. You do not get maintenance. If you're receiving a significant amount of maintenance and you choose to marry an individual who doesn't have a great deal of wealth or income, but just out of love, you absolutely have the right to do that, but you would lose your benefits. So, you know, Shana and Jordan, one of the things we're working on now is an article around this issue. And there's been, in the last maybe 3 years, give or take, some really interesting cases in the state of Illinois, which we have situations where the trial court hears the testimony, they view the evidence, and they make a decision, and then the appellate court comes and overturns it because they view the facts differently. That's somewhere the trial court is upheld, but there really doesn't seem to be any more of a bright line test from the appellate decisions that have come down in Illinois in the last 3 years.
Right. I mean, that's super interesting because, you know, and James, I think we were talking about this yesterday. It's like, even if you present your case and the trial court says, yes, I do think that's cohabitation, it's still not, you still don't know definitively that that's a winner, because just based on the last 3 decisions, which are Miller, this case Walther, and Churchill, 2 of those decisions reached different results on the appellate level. So the trial court, meaning if you go to trial, your circuit judge says, yes, I do find cohabitation. And then the appellate court came back and reversed and said, nope, not cohabitation, permanent maintenance.
Right. Well, and Shana, you know, we tried a case just recently and got an appellate decision back. We won at the trial level and we won at the appellate level, where the appellate court agreed with us that our client having a relationship, an intimate relationship with her boyfriend, did not constitute this continuing cohabitation, which would have necessitated her losing her maintenance. And I thought what was really interesting in our case, while it wasn't a published opinion, the appellate court noted in their decision that if our client and her boyfriend were to break up, the most that would be required for them to unwind that relationship is our client would have to give her boyfriend his swimming suit back, you know, which he left at her place that had a pool. There was so little entanglement between the 2 of them. There wasn't, you know, he didn't keep all of his belongings over at her place. There wasn't financial connections. They didn't have accounts together and so on and so forth. So, but they were allowed to have an intimate dating relationship without losing our client's maintenance.
And I think it was very interesting in that case because they relied a lot on the Miller case, which was similar in a lot of ways. In Miller, the court said the only thing that that couple would have had to do to unwind their relationship was to get rid of their joint golf club membership. That was kind of what they had that was holding them together. But there was nothing, no joint accounts, no beneficiary for the other person on their estate plan, nothing like that. So there was not the intent evidenced that they were going to spend the rest of their lives together, nor was there any financial entanglement. And I think that's probably the biggest one that the court looks at, that I learned from that case and the recent cases, is the financial. That seems to be the big one. Would you guys agree with that?
I think so, and I think that's the most obvious. If you have that component, you've got a really good case to terminate maintenance. If there's someone paying the other's expenses, accounts are shared together, someone has access to the other person's credit card, those types of things, maybe invest in property together, something of that nature. What's interesting about this area, though, and we've all encountered this, right? Any good divorce lawyer, we would advise our clients the same. You're receiving maintenance. Yes, you have a boyfriend or a girlfriend, you know, I guess in the case, either it could be either spouse. It could be, I'm sorry about that. It could be a situation where male or female is receiving the maintenance, and if they have a dating relationship with somebody else, it could be terminated. We're going to advise them about certain things to do and not do. And one of the things we would clearly say is, you know, keep a separate residence. Don't have joint accounts. Pay when you go out to dinner. If he pays this time, she pays next time. If you travel, buy your own airline ticket. Keep your financial lives separate until at such time as you decide to remarry. So that's most of the time what happens. People get that advice, and so they really are in a very serious, committed relationship in it, and probably have some intended permanence, but they play the game enough to keep things separate, to keep the optics different. And that's really where the challenge comes in for the courts, kind of read between the lines, and Jordan, I think you touched on some of those, and maybe you can help the viewers and listeners understand what are some more of the areas where the court will look at factually. What are some of the things that they're going to try to piece together circumstantially to get to that point of intended permanence?
Yeah, I mean, I don't know that financial entanglement in and of itself would mean that there is cohabitation. And again, I think if you again, it's so fact dependent and so holistic, at least from my perspective and what the cases say, that just because you have financial entanglement and nothing else, I don't know that that in and of itself means cohabitation. But I think there's a lot of factors, like you were asking, James, like in any typical relationship, you kind of have to think, and that's what the cases say, like storing clothes at the other's house. How many days per week, per month are you spending the night together? Are you in the same house? Are you going to the other's children's sporting events, school events? Are you helping them with their homework? Are you doing chores around the house at the other person's house? Are you shopping for groceries? Are you cooking meals? Are you doing laundry? Do you have a car key to that person's car? Do you have unfettered access to their home? You know, do you park the car in the garage? Is it something where you walk the dog? You know, you say hey to the neighbors. You're basically putting yourself out there as if you were married and in a couple. And interestingly, these days, Facebook has been such a crazy highlight into those day-to-day activities. You know, we had a case where, you know, we used a picture where the wife in that case took a picture of, you know, a boiling pot of chili and said, you know, my boyfriend, to remain nameless, is lucky tonight I'm making him chili. And that's just sort of one of those things where it's like, all right, we're making stuff together, and we're sort of doing those household functions. Facebook also brings to light trips together, who's there, comments that are made on Facebook. So one of these cases, this Walther case, where the court actually terminated maintenance, and actually the trial court said there was no cohabitation, but the appellate court said there was cohabitation. And one of the principal things in that case was this one Facebook post where the ex-wife and the boyfriend's kids and the ex-wife's kids were all together in this picture, arms linked together, and it said, like, we have such a beautiful family in the comment. And that really hits the nail on the head in what this Miller case sort of described. And this line between, all right, we're kind of intimately dating versus we're cohabiting. And, you know, that level of intended permanence and saying we're a family, you know, we're so lucky to have each other, that I think was a big factor in something the court said, you know what, they're cohabiting and maintenance is no longer appropriate.
Yeah, well, in that, a couple of things, that was a lot. So I think, Shana, a couple of things, and one of which we experienced too is, you know, Jordan alluded to Facebook. I want you to talk about, you know, in our case, text messages very much became a part of that. And I also think another thing Jordan pointed to, which I do want to touch on, is entanglement with children and, you know, blended families and going to ball games and graduations and doing those things where, again, you're setting yourself out as a family. And how does that? So Shana, it was an interesting case because they, in our trial that we won, and the appellate court upheld, their attempt to use our client's text messages with their boyfriend was very much a big part of this, where they professed, you know, feelings for each other and so forth. How does that affect the possibility of maintenance being terminated?
That was a big part of it, because if you read text messages between a couple, you're gonna get some stuff out of there that you can use one way or the other. I mean, we all know how it is when you get in a new relationship and you're, you know, learning about the person, and then you fall in love and you're professing your love, and, you know, you say things that maybe you wouldn't like to go back and have said in writing, and those could be used against you. So I always tell people, don't save your text messages, delete them as you go, don't save your emails. Don't go on Facebook. Don't change your relationship status to in a relationship. You don't need to post anything. It's just not necessary unless you're not that worried about losing the maintenance. So I just tell people, why do it? Why put it out there? It's none of their business. The other thing is you have to be careful of private investigators. You know, that's been another issue that we have had in cases, is they'll have a private investigator camp out outside your house and see how many nights that your boyfriend or girlfriend sleeps over. So when you say, oh yeah, they have their own place, okay, great, but they're only staying there one night a month. So, you know, those are just things to keep in mind.
And hopefully we're not giving away too many of our trade secrets.
Right.
But that is, you know, you have to assume, you know, whether we're doing that for our clients, you know, that's just good advice. You have to assume that everything you say, everything you do in the public eye can and will be used against you. And to your point, Shana, even things in private. You know, if you think your text messages are private to you, they are not in the context of this type of litigation. And so, yeah, we've probably seen and read some things we preferred not to in terms of people's personal text messages, you can imagine.
Including photos. So I tell people the photos never go away. Once you take them, they're out there. So
yes, so
just
be
don't.
warned of your digital footprint. And I think that's a good message, especially even in this day and age. And Apple and Google and all these places are coming together and they're finding more ways to track you and do this and that.
Yep. It never really gets deleted. Nothing.
So Jordan, I think one last thing I would like to kind of get your thoughts on is the enmeshment with children, you know, where someone's divorced, they have a couple of kids, and all of a sudden they're dating somebody, and that other person maybe has kids or maybe not, but all of a sudden we've got boyfriend, girlfriend bringing their kids together, we're vacationing together with the kids, we're going to graduations, ball games, concerts.
Yep.
You know, how does that affect the outcome?
I mean, I think I'll continue to sing from that same hymnal and say it depends really on the facts of the involvement. This last case that came out, I think it was this last case that came out since Miller, was this Churchill case. And it basically said that there was a situation where the boyfriend was tutoring the ex-spouse's son in Spanish and going to his extracurricular activities and even a school graduation. And what the court had noted is that the involvement in the family was sort of consistent with the bloom of an initial relationship. And, you know, I mean, I think that's really interesting because as we talked about, guys, is like, I think as time goes on, right, this concept of marriage and de facto marriage and cohabitation continues to evolve, where it was more traditional gender roles and sort of principles, you know, back 20 years ago, where these cases where it would be like, someone goes on vacation, all right, done. I think it was more traditional in that respect. And now, as relationships evolve, I think the case law is evolving to say relationships are changing, and therefore I think it makes it harder to find cohabitation in today's world. Based on how relationships are changing.
Well, and I would say that is an interesting interpretation. And where I would leave it at for all of the viewers and listeners is this. What Jordan just said with one judge might be spot on. You could walk in that same courthouse to the next courtroom and have a different judge.
That's right.
And have an entirely different view of the world, cohabitation. And so I think what we will leave you with is this. This is an unpredictable, uncertain area of law. And you just have to know that if you are the recipient of maintenance payments, you are always going to be at risk of your ex-spouse coming to try to terminate that maintenance obligation if you're in another relationship, fair or unfair as that may be. That is always something, and you can imagine the more an individual is paying for maintenance and for the longer period of time they have to pay for that, the more incentivized they are going to be to try to litigate those issues, to try to terminate that maintenance, because it's a lot of money. And so Shannon gave some good advice in terms of your digital footprint. In, everybody wants to be seen on Facebook and Instagram and send these, text messages and WhatsApp. That's another one. People communicate thinking, hey, this is between us. It's not. And as good lawyers, we are going to do our due diligence. We're going to hire private investigators. We are going to do anything we possibly can to get at those facts that would support cohabitation if we are representing somebody who is seeking to terminate maintenance. So be aware is what we're really saying. Understand there's a lot of factors. There's no bright line test. We keep saying that. And so if you call a lawyer and they say, you just have to do this, or you just have to do this, or do this, don't do that. If they're telling you that there's some set rules that if you follow this, you're safe, run. That's not good advice, because you're going to get different perspectives from different judges. 3 different lawyers, the 3 of us might view the same set of facts differently. So hope that's helpful for you guys. Shanna's, and we didn't really delve into this too deep, but the idea that during COVID, people are sheltering together. What does that mean? Well, I don't want to get too deep into that because we've got some scenarios where that exact thing is happening as we speak. People are looking, people are watching. So again, we like to leave it with all of you. Be healthy, be safe, be smart. And again, if there's anything we can do, we are open. The courts are closed, but Beermann is not. We are available to you. And on behalf of Shana Vitek, Jordan Rosenberg, thanks again for joining us. Be well.